Yes.
Mtu akitaka kupeleka kesi pale.
Yes.
Which is a procedure. Wakili yako hapo anataka kupeleka kesi, ni mambo gani ambayo anafanya haraka haraka ndio kesi iweze kukubalika pale kotini? Na kama unaweza peleka kesi uambiwe hapana, hii kesi yako haijatosha mboga.
Kuwasilisha kesi kotini is not a complicated matter. Mostly if you are using an advocate to take it to court. If you are using that route, the advocate will reduce the facts you give him to a statement of claim. We call it a plaint in civil cases. We call it a petition when you are seeking rights under the Constitution. We call it an originating motion when an originating summons when you are seeking orders that are not contentious. They cannot be, they are obvious. Once the advocate has reduced that into any of those formats, they are filed in court, court fees paid, and the other side given 14 days to respond.
Who receives your?
The court receives, the court registry receives and issues you the summons to take to your opponent. Now the person or persons you are suing, then those people are given 14 days to respond.
To respond, eh?
Yes.
Now if they don't respond, what happens?
The court enters judgment. That summons has a warning at the base of it that if you don't respond, a judgment will be entered in terms of the prayers of Mr. So-and-so who has brought this case.
Yeah.
Yes.
Again, why should I have all this hassle looking for an advocate taking my case to court? Kwa nini mimi mwenyewe nisiamue? Mimi naelewa shida yenye iko, naelewa kila kitu. Waje tupatane mundu kwa mundu kwa tiba.
The problem is drafting. Drafting court cases is itself an art. Cases get dismissed for the form in which they have come, for want of form. Let me call it like that.
They don't accept the layman language?
No, the layman language is acceptable, and you can state your case in any way that you think you are explaining yourself. Of course, the courts are aware that sometimes a person may not have the knowledge and entertain cases from the public by generally listening to the entire complaint and producing a judgment when somebody is not represented.
Yeah.
But the danger of you losing your case on form, that is, you started by originating summons instead of plaint, is real.
So the form is as important as the content.
Yes. So you have to be careful about that. So that is why most people prefer going to court through advocates. If you go to a typical cause list for one morning, 40 cases before magistrate, 20 mentions, 5 dismissals, whatever happens, 15 hearings, you will find that in 42, 45, the people will be represented.
At this particular juncture, because we are looking at this structure we're killing. I've had some true terms there, mentions and hearings.
A mention is when the case comes up before the magistrate to check whether everything is in order. Can we now start set a date for hearing? Has everybody filed everything that was required?
Okay.
Has somebody
and so we can have more than one mention?
You can have more than one mention depending on what the issues are. Yes.
Wakili, sijui kama ushaikutana na hali kama hii, ni swali ambalo pia mimi hunisumbua sana.
Yes.
Mimi nimepatikana kwa makosa. Alafu kama nimepatikana kwa makosa, nikaona makosa yangu kabisa ni real. Itakuwa ni makosa kubwa. Alafu hiyo makosa ambayo nimepatikana nayo nimekubali nimefanya, lakini nataka utajibu baada ya mapumziko. Lakini nikienda kotini niambie judge kusema ukweli mimi ndio nilifanya makosa haya, kuliko kusumbuka na story mingi hapa, makesi mingi, malizia mimi hapa leo. Hiyo utaangalia baada ya break. Yeah, we are taking a short break. After this we will be having much more. This is Legal Tuesday. Don't go too far.
MBCI Television, transforming lives.
Murang'a County. I will repay you for the years the locusts have eaten. Thus says the Lord. Joel 2:25. Welcome to Mountain of Fire tent meeting, hosted by Bishop Moses Bugwa, RGC Thika.
The direction you take determines your destination.
And Murang'a Pastors Fellowship. Mark your calendar, starting Wednesday the 13th to Sunday the 17th March 2024. Join us for healing and restoration prayers for our county. Ministering will be Apostle John Kimani William.
Wapendwa, hata kama giza itafunika dunia, kuna watu watainuka na kuangaza katika ile giza.
Bishop George Kavyoki.
Hakutakuwa na kilio kwenye nyumba zetu. Hakutakuwa na confusion. Mungu atatuongoza.
Archbishop Kitonga, Bishop Simon Mureithi, and Evangelist Lucy Wangunjiri. These meetings will happen daily from 9 a.m. to 8 p.m. at Mumbi Stadium, Murang'a County. This meeting is interdenominational free and open to all.
Philanthropist ni mtu anakaje?
Philanthropist huyo ni mtu mwenye amefilamika. Ni mtu mwenye amefilwa.
Baba ya Abraham alikuwa anaitwa nani?
Wamai. Wamai.
Usinione hivi hivi, utasemaje kwa kizungu?
Don't see me this way, this way. Don't see me this way, this way.
Ni nani alimeza samaki kwa Biblia na alikuwa anaenda wapi?
Alikuwa anaitwa Noah.
Bombastic side eye.
Alikuwa anaitwa
Jonah.
Na alikuwa anaenda wapi?
Alikuwa ni fefe. Alikuwa ni fefe.
What is going to help us here and in Kenya is the power.
Apostle Subeyuri of Sinum Church is back.
And the fire of the Holy Spirit.
Every Tuesday at 7:30 p.m. And repeats on Thursday, 9:30 p.m.
The Bible says in the book of Ezekiel that wherever this river went, everything lived.
Stay connected.
Even dead things came back to life.
Stay blessed.
Wherever we go, there should be life.
Buda, unaonaje hii moti? Buda iko fiti mbaya. Lakini si ulisema uwezi nunua dinga before ujenge. Sasa utaipack wapi? Nitaipack huku tu, bali shando upload tena naanza kujenga. Wa? Buda, hebu nichanue.
Welcome to the Delight Nakuru, brought to you by Username Investments. Perfect for your dream home, investment for holiday home, going only for 799,000 shillings for 1/8 of an acre. There's borehole water, estate gate, graded access roads, electricity and proximity to modern high-end schools, hospitals and other social amenities. SMS Nakuru to 20321 or call 0725 000 222.
MBCI Television, transforming lives.
Katika kipindi cha The Legal Tuesday na tunaongea kuhusiana na masuala ya kesi kotini. Kama una swali kwa wakili yuko hapa katika studio zetu, 23814 is our SMS number na vile vile WhatsApp 0721105105. Wakili, nirudia kidogo. Mimi kuna mtu ambaye ako na kesi kotini, lakini ameona ako na makosa kabisa na amekubali makosa yake.
Yes.
Na kwa sababu naona kama kesi ni kuja kusema kujitetea hukufanya, kama nikubali nilifanya makosa. Kwa nini nipitie hiyo shida yote, makesi mingi? Siniambie wakili mimi ama jaji nimefanya makosa, basi fanyeni uamuzi hii mambo tumalize.
It is normal to enter a plea of guilty. Unaweza kukubali na mashtaka na utahukumiwa. Lakini hilo swali mara mingi tunaulizwa kuhusiana na cases za murder. Murder is a technical crime. Killing somebody, which is called homicide in English, is not murder. There are several things that go into murder. You must have intended to kill. You must have planned and executed your plan to kill that person. The intention, I remember Mola once talked about mens rea, the thinking that you are going to kill this person. So if you came to court on a murder trial and you pleaded guilty and said, yes, I'm guilty, we will not record it as that. We will record that you are accepting the facts. You will be remanded. We will now give you time to think through the matter. Several people will be involved. You have to be represented by an advocate. It has to be absolutely clear that you are in the right mind. Of course, you can't be brought to court for murder before you go to the Provincial General Hospital for mental checkup. All of it must start there. You must have been declared mentally fit to stand trial.
And if you are not mentally fit, that case ends at that point?
No. You may get a sentence that is worse than if you went through trial. You may get detained at the pleasure of the president. So that's an endless detention that is not known when it will end. So a trial might even be better. But people who are insane but guilty are dealt with under the Mental Health Act, and they are detained at the pleasure of the president, especially in murder cases. Yes.
Before we enter to our main topic today, Mangicho, one important issue here, we have heard about, how do I put it, I'm getting lost, the issue of resettling the matter outside court.
Yes.
You know that is correct?
Yes.
How does it come in?
When you file a civil case, obviously you have a dispute with somebody you had a relationship with. Either that person was purchasing an animal from you, you were doing some business with that person, or you are related legally in some other way. So the general view is this, that wewe na mwenye umeshtaki mnajuana better than us in court. So if we give you an opportunity to discuss, you can agree kwamba hii 1,100 nilikupea, you already owed me 20, let me give you 80 tumalize hii maneno. The court will record that as a settlement of the matter and close the file. That is a settlement out of court. In criminal cases, especially in matters of stealing by servant or stealing by people who were in employment, who had a relationship, a long relationship, the court sometimes defers the trial of the criminal part, that is that you have broken the law by stealing, and they says, let's give you time, pay the 300,000 that you stole from the till of the M-Pesa shop you are working in. After you pay the money, you will come. We will consider that as a mitigating factor in the stealing. So that when you come back, the court may say, your punishment shall be non-custodial, that is, utafungwa kifungo cha nje, utakaa on probation for 2 years or 1 year or 6 months. If it is very minor, you might be told to do some manual work around the court and finish and go away.
Okay.
Yeah.
And maybe before of the issue of the resettling the matter outside court.
Yes.
I don't know, away from the issues of divorce in domestic disputes,
yes,
can couples take each other to court on misunderstanding? Because you find people, they are not understanding each other.
Yes.
There's a lot of squabbles. I don't know whether we can, away from the issue of maybe divorce?
Divorce cases have an inbuilt process in which once one party succeeds on 8 of the 4 grounds, divorce can only occur on 4 grounds. Once either party succeeds in any of them, they are given a temporal decree and usually the period is 6 months. They can go discuss and come back in 6 months and say, we do not want to make this temporary divorce permanent. We have reconciled, or we are abandoning the cause. That happens quite a number of times. In fact, I suspect that 40% of divorce matters end up in that kind of an arrangement sometimes. In other cases, like which don't have a divorce element, normal civil cases, it is rare to have a matter deferred. It is either you are postponing the payment, the judgment, or something like that.
Okay.
Yes.
Very good. And
before we continue, Mangicho, I think we can now jump to the streets and hear what the public are saying regarding to a topic of today, cases za rufaa. Kwa hivyo kidogo tu tuingie kule mashinani tusikie wananchi wana yepi kuhusiana na mahakama zetu.
Shukrani kwa kuzungumza na runinga ya MBCI. Leo hii tunauliza, je, wewe unaona serikali imefanya bidii kuhakikisha kwamba wananchi wanapata elimu ya kutosha kuhusu sheria za nchi?
Kwa maoni yangu mimi sioni, sababu si watu wote wanajua sheria. Juu wenye wanajua sheria ni watu wakubwa kubwa. Sisi watu wa chini, maana sheria hatujui ai tufahamu vizuri. Sasa mimi kwa maoni yangu naweza omba serikali at least iwe na waelimishaji huku chini, wanaweza kuja kuelimisha watu wadogo kuhusu sheria.
Na je, wewe mwenyewe sijui kama unafahamu kukata rufaa inamaanisha nini katika lugha ya sheria?
Kwa maoni yangu mimi venye nafahamu kukata rufaa ni mimi nimeshikwa, nimefungwa maybe for 10 years. Kuna ile unaweza appeal, ukate rufaa, kesi yako useme iko justice, irudiwe tena. Kwa maoni yangu hiyo ndio najua tu.
Wakati unakata rufaa, kesi imetoka katika mahakama kuu. Kesi hiyo huenda katika mahakama ipi wakati unakata rufaa?
Ukikata kwa mfano ikiwa ni kuna court appeal. Kuna ile court appeal. Sasa ukitoka kwa koti kuna court of appeal. Ndio una appeal kuhusu kesi yako.
Wengi hawajajua mambo ya sheria. Hiyo ndio shida. Sheria wananchi wengi hawajaielewa. Ndio sababu wanaumiaga juu ya kukosa kujua sheria. Wangekuwa wanajua sheria, hawangekuwa wanaumia. Hiyo ndio shida.
Na we mwenyewe unafahamu kuhusu kukata rufaa?
Sijafahamu.
Na mahakama za humu nchini Kenya, unaweza nitajia baadhi ya mahakama humu nchini Kenya?
Mahakama ni nyingi za nchi za Kenya, lakini hatujajua sheria kuhusu sheria na rufaa. Hatujajua.
Sijai kata rufaa. Hizi rufaa ziloleka zina mapendeleo. Zinapendelea wale watu wana kitu. Wewe toki kata rufaa yako inaweza maliza hata miaka 10 bila kuona.
Kukata rufaa inamaanisha nini kwa?
Ni ile kama umeshika ukafungwa miaka 10 ama 20, unarudisha rufaa ili uweze kupunguzio kifungo ama uweze kunini. Huwa inatoka kwa mahakama kuu ikienda kwa ile appeal. Sasa ukienda kule kwa appeal unakuta kama wewe ni mnyonge utaishi kuwa mnyonge. Kwa hivyo serikali ikuje huku chini na iweze kuelimisha watu wa huku chini na iweze kuonesha kuwa wanafaa hata lao kurudisha appeal na waweze kusaidia ile serikali. Serikali iwawekee mawakili ili waelewe kesi vile imefanywa. Kama umefungwa kimakosa, kule wengi wamefungwa kimakosa kwa kuwa hawakuwa wamefanya makosa, kila hawakujua njia ama kuelewa kesi vile wanaweza ifanya. Kwa hivyo tunasema hivi, serikali ikuje hapa chini na isaidie watu wa huku chini, iache kuangandamiza. Wao ndio watakuwa wakifanya nini? Wakifungwa. La hali ni kuelewa hawaelewi sheria.
Kukata rufaa kulingana na mimi, maoni yangu ni kwa appeal. Wakati umepelekwa labda kotini, sasa unaenda na kinini fulani unaanza kwa appeal. Hiyo ndio kulingana na maoni yangu. Kukata rufaa ni kwa appeal. Kutoka mahakama ya chini ikienda ya juu ya upeo.
Serikali haijatia bidii kutuelimisha sisi wananchi kuhusiana na haya maneno ya kuapili. Kwa kweli kwa wengi wetu hatuelewi ni namna gani unaweza appeal, kama umefanya makosa ni nini utafanya ndio uweze kuapili. Yes.
Kwa hivyo wewe, kwa maoni yako, unafahamu ama haufahamu kuhusu kukata rufaa?
Kwangu mimi sina ufahamu sana, ila ni kidogo tu, lakini sina ufahamu sana, ila ningesema kwamba serikali iweze kuzidisha na kutusomesha zaidi. Kwangu mimi chenye naelewa ni kwamba inatoka kwa ile mahakama ya chini ikienda ya juu. Yani Supreme inatoka kwa mahakama ya chini, yani ikienda kwa Supreme. Kwa hiyo ambayo inaielewa kidogo.
Ya kukata rufaa ni ile kama uchatoseresha, utaridhika na ile uamuzi imetolewa na mahakama. Sasa ndio nakata rufaa isikilizwe kwa mahakama ya juu ama mahakama ingine.
Za serikali pia hawafuati sheria, so hiyo ndio inafanya inakuwa ni kama complicated kidogo, hadi inakaa kama mwananchi amesahau. Lakini tunajua, tumeelimishwa, katiba tunakumbuka tulipewa, tulichambua, tunaonanga tu daily basis, tunasomeshwa polepole, lakini ni kila mtu anaitumia hiyo sheria, sisi wananchi na pia wenye kwa serikali.
Na je, unafahamu kukata rufaa kwa lugha ya kisheria inamaanisha nini na hufanywa na mahakama ipi humu nchini?
Kukata rufaa kwa maoni yangu nafikiri ni unaweza kosa kutosheka na uamuzi wa mahakama ya chini, ukaweza kuomba nyadhifa ya kusikizwa tena kwa koti ya juu, na unaweza kwa high court uende kwa Supreme Court.
Sheria kabla ipitishwe ingezungukanga kwa muda fulani, ndio angalau watu kama sisi walio chini itufikie kwa haraka. Kukata kesi, kufanya uamuzi wa kesi fulani tu. Kutoka chini, I mean low court, inaenda kwa high court, kitoka kwa high court inaenda Supreme Court.
Alright. Inaonekana Wakenya wana habari bwana. Wakenya nimeshangaa. Wakenya. They're very informed.
Ndio Wakenya hapo wanazungumza.
This is it. Kenyans generally know the law. I sit in an office and I meet various people, a number of people over the week, over the month, over the year. Nobody ever comes without telling you or suggesting what remedy is looking for. So I know information out there is people know the law that affects them. Or whenever something happens inalingana na inamuhusu ama inahusu mali yake, Mkenya utafuta sheria na uipata. So sio ukweli kwamba Wakenya hawajui sheria, ingawa kuna jukumu kwa vyombo vya habari kama nyinyi hapa na wengine civil society kuelimisha watu kuelewa sheria. Ndio wakinyimwa sheria, kama naona kila siku watu wakija kotini mahakamani kule Kericho, Nakuru, Kisii, siku hizi administration ya koti decided to put up gates. Kisheria, insofar as I know, the gates in courts are illegal structures. A court is a front street affair that should not have any control over anybody coming in and going in. What you may control is the courtroom, so that the proceedings are not disrupted. But having a gate with a private security telling people you can't go in, you can't come back, is not the proper thing to do.
Okay.
Yes.
Now I think Magicho we can go direct.
Yeah, we can actually go direct and maybe hata kwa vile ambavyo labda watazamaji wameweza kuelezea, wale ambao wale ambao tumeona pale wakiujua kulingana na vile ambavyo wanaelewa maana ya kukata rufaa. Nafikiri tutaanzia tu hapo wakili, kwa mtazamaji ambaye anatutazama, ili kuweza kuelewa kabisa tunapozungumza kukata rufaa or to make an appeal.
All of them were right except one. Wa mwisho mwenye alisema ni kupeleka kesi mahakamani.
Yes.
Kukata taking a case to court is not filing an appeal. Appeal is a special term. It refers to a situation where you are not satisfied with the decision of, say, a magistrate's court. You appeal to the High Court. If it's a criminal case, you appeal directly to the High Court. If it's a civil case, you go to the High Court. If it's a land matter, you go to the Environment and Land Court, which is at the same level as the High Court. If it is a matter involving rent and the tribunal, you go to the High Court. Okay. You bring your judgment to the Magistrates Court, it gets adopted, you go to the High Court. But I think the law has changed now, you can go direct.
What can make you not to be satisfied? What are some of the issues that one would consider?
It's perhaps a finding that is against you. You've been told that you have not paid rent for 2 years when you have receipts indicating you've paid the rent, or the judgment does not satisfy you in various particulars. Now, from the High Court, you appeal to the Court of Appeal. It seems everybody knows the High Court and the Supreme Court, but they don't know anything about the Court of Appeal. The Court of Appeal is a special court created. It was the final court in Kenya up to 2010, before the Supreme Court was created. It is a court that hears appeals from the High Court, from the Environment and Land Court. Those two courts that are of the same level, appeals go to the Court of Appeal. It is very rigorous because when you get a judgment, the court will tell you, if you are not satisfied, you give notice to the other party and you filed it in court within 14 days that you are going to file an appeal. Then after you give notice, you apply for proceedings, you apply for the written copy of the judgment to be certified, then you create what we call a bundle of documents to the Court of Appeal. If it is from the High Court to the Court of Appeal, when the Court of Appeal receives your bundles, they will give you directions.
Okay.
Directions are these. It tells you, you will come and argue your appeal here on such and such a day. Or you will file 10 pages of submissions before the end of this month. We will read them and write a judgment. That is what it means. If your advocate tells you, tunangojea directions, ndio tuendelee na apili yako. He means he has not been told the format of proceeding, whether by submissions or by going to court and arguing the matter orally. Yes. Continue. The Court of Appeal has powers to review the entire evidence and come to its own conclusion and change the judgment in your favor if you are appealing, or maintain the judgment. It can maintain the judgment and say the judge was correct, or it was not correct to this extent, so they can adjust.
To give you more harsh judgment.
It may not be more harsh. They may say that element number 4, where you are told to pay 4 million damages, is not justified. We remove this one. The rest of the judgment stands. So it is an adjustment process to make sure that justice is done.
Yeah.
So the Court of Appeal has those rights. But I will not advise anybody to go to the Court of Appeal in person as a citizen. The rules are very, very strict. You will make one mistake and your appeal goes, and you know you are at the end. It's the final stage you are. You can't go further than that. So it is better that you get an advocate, akuwekea kesi vizuri, afuate sheria kwa kutengeneza bundle. It's a very, very, very rigorous process. He has to make about 7 copies of the same document from all the evidence and everything that has been filed in the other court, then apeleke mahakama.
Yeah. Just to understand better, Wakili,
yes.
You have talked about the Court of Appeal can go through what was went through the High Court.
Yes.
Is there a situation where, because that is the understanding of many people, that the Court of Appeal, when you appeal against a case, it is just it starts all afresh again in the Court of Appeal? Is that true?
No, not necessarily. What happens in the Court of Appeal is that the Court of Appeal shall review, that is the law, shall review, itaangalia upya ule ushahidi wenye ulitoa kwa hii mahakama ingine. It does that right. Lakini ikiwa your appeal ni apili, like you appeal from the Magistrates Court, ukakuja High Court, hujaridhika ukasema let me go to the Court of Appeal. The Court of Appeal cannot review the evidence. You can only do the second appeal in our system because on what we call matters of the law. But facts under the law are appealable when you are filing the first appeal. Hii ni appeal ya kwanza, una file from from the magistrate court to the high court. Yes.
Okay. You had mentioned about there are some cases which are not appealable.
Yes.
Then what are these cases that are not appealable?
Very, very, very rare circumstances, like applications. There are special applications that we do, interim applications in a case, where the judge says that if we allowed an appeal to go there, it will disrupt the continuation of this case. You appeal for a particular order, it really does not involve a whole case. It is interim orders that are that will disrupt the motion of the case, that are mostly unappealable.
Okay. And Wakili, when you're looking at in terms of looking at the issues or the factors that maybe one can actually be in a position to look into before they make this appeal.
Yes.
What would be the role of an advocate? What would be the role of maybe a lawyer?
You are appealing because you are saying there are errors in that judgment. Okay. The errors will be in terms of interpreting the facts. The errors will be in terms of interpreting the law. The errors may be errors of calculation. That I was employed in that company for 21 years. The judge has given me benefits for only 12 years. So I need to get my extra 9 years that have been lost in this judgment. So you need a lawyer to tabulate those in terms of grounds of appeal and explain them and point them out where they are in the judgment, so that the Court of Appeal does not again call you to the stand to state your case. It uses the evidence you used below, which you are saying has not been properly appreciated. Nilitoa ushahidi, lakini ushahidi haujazingatiwa kwa haya na haya na haya. Hiyo ndio naambia appeal.
Thank you. And does it in any way point to the incompetence maybe of a magistrate or a judge who has had that particular case that now is going maybe for appeal, or there is room for consideration of these different interpretations of this particular matter?
You got it right. It's a matter of interpretation. If you give me a sentence right now here that is 20 words, well, let's limit it to 20 words, that has a comma, an apostrophe, and a full stop at the end of it, that is punctuated properly, that uses more than 3 punctuation marks, and it's 20 words wrong, I can give you 4 meanings of it.
Yes.
By moving the commas and even removing the full stop. The period can change the meaning. So your facts have been given to a judge. He has interpreted them in his way. The judge has jurisdiction, what we call decisional independence. He's independent to make that decision, so that he's only checked by the appeal process. The appeal process is what we will say. He didn't consider this. Yes, you are right, he didn't do this. It has nothing to do with the competence of the judicial officer. And it has nothing to do with the... when we are going to appeal, it is very rare to appeal on grounds of incompetence or corruption. Because
actually, that is what I wanted to ask. If one appeals and the win at the appeal stage, does it really mean, or would it really be interpreted to mean that maybe the previous court, the previous magistrate or judge was compromised?
No. It's a matter of interpretation. The decision on independence is there. He has exercised the jurisdiction and thought about the facts you brought to them and come to a decision. Once they make that decision, it is not that they are compromised or incompetent. That is the independent decision. Okay. When you take it to the appellate level, the words used are that the order for this is substituted for this. The appellate court substitutes the findings. So it doesn't have to do with competence or compromise of the first judicial officer.
Thank you. Yes. Magicha, before we are heading to the legal terminology, just to alert for about 2 questions. As we come back, we'll try to respond to them. This one is very direct. Wakili, can one oppose divorce case or it's all granted? can one oppose divorce case or is all granted?
Yes.
And then we have another one here I wish to read. Yes. I don't know, but it's talking about land. I think I'm going to read it later on because it's very long. Yes. I'm going to summarize. But before then, Mangicho, I think we can go to today's legal terminology and also bring what we call the inside law later on.
Okay, and of course we have our legal terminology for the day. And Kagi, at least I think today you're going to have some Latin. That's our terminology for today. I'll just pronounce it, and maybe Wakili will help us to see whether we'll pronounce it well. Sub poena duces te sum. Sub poena duces te sum. This is a lot of Latin. But we are talking about a command to a witness to produce documents. A command to a witness to produce documents. We can also say is a type of sub poena that requires the witness to produce a document or documents pertinent to a proceeding. So we are saying it's a command to a witness to produce documents, or a type of sub poena to produce, or that requires the witness to produce a document or documents pertinent to a particular proceeding, or maybe pertinent to a particular case. That is what we mean when you talk about sub poena duces te sum. But of course we have Wakili here. He'll help us to break it down. There's a lot of Latin jargon here. Wakili.
We have avoided it as a profession, the law profession, using these terminologies for some time now. But a command to produce a document is usually given to a person who has that document in their custody, or who is expected to have them in their custody.
So we're talking about a document like
for example, if there was a dispute on a child, and the registration of and the birth certificate is required, I produce a birth certificate saying that the mother of this child was Grace. Another one is coming up with a document saying the child was born by Joyce. So we will need the original register from which these things came. So you get an order from court to the registrar of that particular county to come with the original booklet from which these birth certificates were plugged, and show who the mother who filled the forms is on that dispute. It is usually documents in custody of government officers, all people are expected.
So in most cases the command will be to the government?
The command will be to a government officer. It may also be a command to your pastor to produce the register of weddings is presided over, if your wedding is in dispute, whether it took place.
Okay.
Yes.
Okay. Those who are in custody of those documents.
Yes, the ones who have the custody.
Thank you, thank you, thank you. Kagi, that is our term for today's Apoena Duces te Sum. You can take us to inside the law now.
Thank you. And Mangicho, if there's something I was really scared about, is you telling me to pronounce that word.
Latin has no problem with pronunciation. You pronounce every letter that is there. Every letter.
Every letter is pronounceable.
Yes, tecum, that is.
I was about to give Wakili today a challenge to do it. Yes, today's Inside Law, we are talking about the United Nations Appeal Tribunal. We are heading to the United Nations. We have an appeal tribunal, which I'm going to give you details of what is happening there. And the United Nations Appeal Tribunal is the second and final instance of appeal within the UN internal system of justice. The UNAT was established by the General Assembly by the year 2009 as part of the new UN internal justice system, replacing the old United Nations Administrative Tribunal. And this UNAT reviews within its specific jurisdiction appeals against judgments rendered by, these are the things that make the UNAT review your cases. Number one, if the dispute tribunal of the UN relief has given a different opinion by the UN Dispute Tribunal, and third, works agency for the Palestine refugees in the Near East called UNRWA. But this appeal, or the appeals tribunal, shall be competent to hear and pass judgment on an appeal filed against the judgment rendered by the United Nations Dispute Tribunal. So all the cases which come to this appeal tribunal emanates from what they call the UN Dispute Tribunal, whereby there are various organizations or maybe groups of people who have not agreed on something. And if you have not agreed on something, then you can be able to take this case to the UN Appeals Tribunal. It must have asserted that the dispute tribunal has, number one, is exceeded its jurisdiction or competence. That is number one. Number two, it has failed to exercise jurisdiction vested in it. Then number three, has erred on the question of law. So when the three things appear, then you can take this case to the tribunal at the UN. Then we have, it must have been committed an error in the procedure, such as the effect and the decision of the case, and then erred on the question of fact, resulting in a manifestly unreasonable decision. Now, maybe you're asking, where does this tribunal or maybe this appeal operate from? The appeal tribunal shall exercise its functions in New York, and then, however, it may decide to hold sessions in Geneva or Nairobi. And finally, the appeals tribunal shall be composed of 7 judges, and a judge of the appeals tribunal shall be appointed for one non-renewable term of 7 years. That is the end of our presentation on the UN or United Nations Appeals Tribunal for now.
Thank you so much, Kagi, there. Quite comprehensive there, looking at the United Nations Appeals Tribunal. And of course, Wakili, this would basically focus on member states of the UN?
Member states of the UN, those states that have ratified treaties and are part of the UN system. This is not a matter that will be common and affect common people. It is to deal with international trade, international boundary disputes, and those kind of...
also in most cases relating to maybe how our country is affected.
Some states claims on riparian rights over the oceans and those kind of things. Very, very rare cases that an advocate can live through without ever coming across one. Yes.
Wow, wow.
Yes.
Absolutely.
Yes.
Okay. Yes. Yeah. As we continue, Wakili, maybe on the same, maybe just in a summarized way.
Yes.
At what situation can maybe a country or maybe an organization take its case to UN? Maybe.
Once the dispute falls under the terms of the court, all these courts are set with terms that they shall resolve issues of this nature. That's boundaries of countries, ocean shelf issues, trade issues between countries, refusal of jurisdiction, like you borrowed money in England, you ran to Kenya, then Kenya refuses to enforce the judgment. Those kind of matters that are generally complicated matters of international relations. That is what will go to the court, then end up at the appeals tribunal.
Yeah.
Yes.
Do UN has a court?
There are specialty courts in the UN. Sometimes they work through specialized tribunals, like the Tribunal for Rwanda, but they have an International Court of Justice that is a permanent court. They have an International Court for the arbitration in commercial disputes. That's a permanent panel. Those are the panels that generate the appeals that go to this appeal court we are discussing here today. Yes.
And there's some situations whereby you see some cases which are being heard in Kenya.
Yes.
Some guys who are not satisfied with the results of those judgments,
yes.
They say they're going to take their case to Arusha, Tanzania.
Yes, the first challenge with that kind of a thing is that you must establish that the jurisdiction of the Arusha court exists over the issue you are coming up with. Mostly it will be a governance, a democracy thing, in that court has the duty to promote the democracy and good governance. So whenever you see that sentence in the objectives of the court, somebody can say, I'm coming under this clause to pray that you assist me and enforce this kind of condition in my country. So it is possible to do that. But the first challenge is usually placing your complaint within the jurisdiction of that court. Yes.
I'm really suspicious whether our countries in the region really respect the outcome of the Arusha court.
It is our stage.
Like the Ogek case and many other cases.
It's our stage in development. If you look at the development of the African nations, the law is seeping into a culture now. If you look at the filing of succession causes, the management of estates and what have you, people are knowing more. The law is permitting the society, so they will start enforcing them by when the rule of law becomes our culture.
Yeah.
Yes.
Wow, thank you.
Let me revisit the question. I don't know whether you
the first one was
about the divorce. Let me
is a divorce guaranteed?
Can one oppose a divorce case or it's all granted?
No. The reason he is asking that question is that the fourth ground upon which anybody could seek a divorce is a general ground that says that the marriage is irreparably broken down. So when somebody comes and makes that plea that the marriage has broken down irreparably, most of the time it is difficult to, they only have to demonstrate discordance, disagreements and that kind of a thing. But all divorce matters are contested matters. You can file a response. You can also file a cross petition for appeal as a response. And they say the grounds that are being proffered are equally true to the petitioner and not to me. If it is desertion, she is the one who decided, Ama is the one who decided.
How long does it take for a divorce case to be mature?
It doesn't take long. You can go through a divorce within a year and conclude it, including the waiting time.
Yeah.
There are not many because the church structures usually try to resolve those kind of problems, like Catholic, the ACK, all churches generally try to keep away from divorce.
Yeah.
Yes.
I also wanted to ask Wakili, when it comes now to appealing these cases, for example, taking a case maybe from the High Court to the Court of Appeal, there is the issue of cost.
Yes.
Sometimes you hear the judge saying, I don't know, the two parties shall bear the cost.
Their own costs.
Yes.
You don't claim costs from the other parties. Most of the time costs follow the event, that the one who loses pays the costs. But there are situations where the case is between a brother, and the court considers that awarding costs will extend the dispute beyond the judgment. That is, you will go home to start demanding money from each other and end up having lengthening the dispute. So if he has done substantive justice and said...
So we are talking about the cost of launching this case?
Launching the case, the entire costs for doing the case. Advocate fees and all that. So sometimes the court feels that...
so if you lose the case, you can be asked to...
You pay the costs ordinarily in all circumstances. But there are circumstances in which the court, considering the relationship between the parties, says, let each party pay their costs. Meaning that the court does not does not wish to use the judgment to extend the dispute beyond the judgment. I have done the justice. If it is land, I've divided between you equally. You go and pay your own costs. Yes.
Okay, like there's a land question here.
Yes.
Anasema shamba la babu liko na babu vile alikufa. Cousin was akina baba akabadilisha jina akachukua title deed but baba akona search inasema babu tufanye nini please? Umeelewa?
Land that is registered in a deceased person belongs to the estate of that person. It is a criminal offense under section 45 and 51 of the Laws of Succession Act to tamper with an estate, the estate of a deceased person. So in general terms, that person has committed both a criminal and a civil offense. What that person should do is aelekee mahakamani aseme hii ni estate ya so and so, huyu ameichukua by interfering with the estate. The court will guide. After that, you will get guidance on how to move on. Yes. So long as the title was transferred after the death. Yes.
Kuna ingine hapo iko very interesting. My sister alinunua shamba na akashindwa kulipa.
Yes.
Haya, ametafuta mtu anunue ile shamba ili arudishiwe pesa. Arudishie pesa mwenye shamba ataki, afanye aje?
That's a technical question the person is asking. What happens to a frustrated contract? All contracts, ya kuuza gari, ya kununua gari, ya kununua shamba ya nini, has about 4 remedies. It will either be fulfilled and everybody will be happy. It can be frustrated by one of the parties. No, it can be frustrated by circumstances, such as one of the parties missing money to conclude it. That is frustration. It can also be frustrated by an act of God. Something happens that is beyond the control of these people here. It can also die out of breach, outright breach, that I don't want to fulfill part of my contract. So that person is asking a technical question that is almost a whole textbook. What do you do with a frustrated contract? The remedy in frustration of contract is adjustment of the parties kuwarudisha kwenye walikuwa kabla wanunue hii shamba. Yule hawezi kuweka pesa na aweke shamba. The person mwenye alikuwa anauza must offer a remedy yenye inarudishia huyu pesa kama yeye sio mwenye alikuwa na makosa. That person most likely is saying, you are in breach of the contract, I'm not refunding the money, I'm not giving you the land. You see that? Now, ile solution yenye itapatikana hapo, suluhisho ni somebody sitting over the documents from the contract, the conduct of the parties, the reasons for frustration. Did the sister lose her job so she was not able to any longer buy the land? There must be an explanation to get into the right solution for that. Now, the question itself cannot give you an automatic answer. It depends on what happens. What happened?
Okay.
Yes.
And then now you need to go to, before you continue, you need to go to the profile for today.
Oh, the legal profile.
Yes.
Of course, I believe we have the legal profile for today, as we always do in this particular program, where we focus on a prominent individual in the legal space. And today, Kagi and Okili, our focus will be on Justice, Lady Justice Kalpana Rawal. Of course, you can see her picture there. 15th January 1946, born in Gujarat State, India. 1973, moved from India to Kenya. She holds a Bachelor of Arts degree and also a Bachelor's and Master of Laws in Constitution and Administrative Law. Now, Lady Justice Kalpana Rawal received her LLB and LLM degrees in India, where she practiced for 3 years. She was under the tutelage of Prafula Chandra and Natwarlal Bhagwati, who later became the 17th Chief Justice of India during that particular period. I think we still have some more information about Lady Justice Kalpana Rawal. Of course, we've talked about that. 1975, she was a teacher of both administrative and regular police officers at Lower Kabete. Of course, we've been able to see that. And then in 1975, she became the first woman lawyer to set up private service in Kenya. Very important that is back in 1975, became the first woman lawyer to set up private service in Kenya. In 1999, Justice Kalpana Rawal was appointed Commissioner of Assise and also Judge of the High Court there. We're still continuing. On 22nd of February 2013 to 14th of June 2016, she served as the Deputy Chief Justice. That was 22nd of February 2013 up to 14th of June 2016. She served as the Deputy Chief Justice, and the Lady Justice Kalpana Rawal retired at age 70. That is our legal profile for today. Lady Justice Kalpana Rawal.
I love her legal journey.
But what is not known about this lady, and which is more influential than that, is that she was a pioneer of the upstairs commercial colleges in Nairobi that trained secretarial, typing, and those kind of things. You see, the college that was in Imenti House, which had a branch up the road in Moi Avenue, and several branches in Thika and all over. She was an investor in those things. So when she was practicing in the 70s, she identified a gap, and they said, let me start this thing we call commercial colleges. So people have done accounts in account certificates, typing, secretarial in our colleges, until everything moved to computers and typewriters died a natural death. She was very instrumental in that. Yes.
And I love that one time she was a trainer for AP and regular police.
Interesting. Other than just the legal.
Other than that, she used to teach, I think, in the Kenya Polytechnic. I think that's where she got the idea from. She was doing the Kenya Polytechnic. Yes.
That is awesome. Yes, I had a question, Okili, even as we come to we near the close, about finding a situation whereby maybe a judge can disqualify themselves from listening or hearing an appeal case.
Yes.
What are the factors?
Mostly it will be relationship with one of the advocates or relationship with one of the persons that have filed the suit or defending the suit. We sometimes find ourselves in a situation where a case is filed and it's going to be presided over by a brother-in-law, a sister-in-law, something like that. We generally give it a professional distance.
Also, in most cases, maybe personal relationship.
Personal relationship. The other situation is when a party forms the opinion that the judicial officer is unfair to them or has been unfair to them in making interim orders, in managing the case, so they feel this is wrong. Sometimes applications for recusal are made out of ignorance. I've seen a case where somebody will ask the judge to recuse himself, achitoe kwa kesi, simply because aliambia the person on the other side, wewe, wakili wako acha file document hii na hii na hii. And umwambia file, ndio hii kesi iendelee. The other side took it that the judge is assisting the other side. So, although it was he had adjourned the matter for the reason that that person had not filed a critical.
So either the side of the complainant or the defendant can request for a particular judge to disqualify themselves. And
not to disqualify, to recuse themselves.
To recuse themselves, yeah.
Disqualification is more technical and very difficult circumstance. The judge will be disqualifying himself, perhaps because the wife is a director of the company that has been sued. That is now, that's a recusal, let's call it disqualification, but technically disqualified persons cannot preside over that matter because of underlying legal issues that is affecting them. See that? Okay. These other things are innocent circumstances, let them call it that. A relationship to the advocate, a relationship to,
Okay. We are coming across the program. Maybe in a few seconds, maybe you are sum up and advice to the public as they seek some legal redress.
The public knows the law, and they know a lot of law. As long ago as when I was in primary school, I remember a case I came to meet in university. A neighbor sued another for the reason that he was a cattle purchaser. He purchased the commercial cattle purchaser. They passed through his land and they go to another land he had hired on the other side. So this neighbor came to court and said, this man is spreading diseases on my land. All of us in the village said, he doesn't want development. But when I went to college, I realized that that man was raising an extremely important case. So wananchi know the law. Let's not fear the law and say that you don't know it, but jaribu kujifundisha one way or the other, procedures kuendelea utakuja kujua yote. Kama land laws in this country these days, nobody comes to the office to tell you, to ask you an opinion. Anakuja na kuambia nataka ufanye hii na hii na hii. Whatever he calls it, you realize that there is a legal terminology for what they are talking about. Yeah. Na tujaribu kujifunza na kufuata sheria.
Maybe just one more, Kagi, before we end, because in most cases, as you say, it's an advocate that would maybe advise a client on whether to appeal a case or not.
Yes.
But there have been allegations of some advocate maybe taking advantage of the client. How would a client determine?
Creating an appeal out of facts that are not there. Yes. Anyway, this is what I will say about that. Ile kitu yenye umenyimwa na koti, how does it affect you? Is it something that you can let off and go on with your life? That is a decision for the client. So the advocate here is a functionary of the client. So if the client feels that justice has been done, hii kitu naweza kuachilia niendelee na maisha yangu, that is what the judgment has already told you to do.
Okay.
You just do that. But if for any reason you feel you want to appeal, you appeal.
Yes. Sawa sawa. Tunakushukuru sana wakili Bwana Ondiki kwa sababu ya kuja katika studio za MBCI TV kwa siku ya leo. Tusaidie kuweza kuchanganua masuala mbalimbali yanayohusu sheria. Tunakutakia kila laheri katika kazi ambayo unafanya. Mimi kwa dakika moja tu na mahali ambapo nahudumu.
I'm an advocate in this town from around 93 to date. With a few periods when I worked in Nairobi and other organizations. I'm located in AIC headquarter building. It is known as Nehemiah House, opposite what we call Kenjab Motors, next to D&D House. We're between D&D House and Fale Hospital, the big building there. That is where we are.
Awesome.
Yes.
Alright, we thank you wakili kwa sababu ya kuja katika kipindi cha siku ya leo. Tunakushukuru sana kwa sababu ya wasia wako siku ya leo. Na hadi wiki ijayo wakati wa makala mengine kama haya, mimi naitwa Paul Kagi na kutakia wiki njema.
Bila shaka na mimi inajulikana kama Mangicho Mola. Kesho tutakuwa tena hapa pamoja tuweze kusemezana kuhusiana na masuala ya uongozi kwenye kipindi cha The Leadership Wednesday, kuwa na mchana mwanana.